Legacy Precious Metals is the company that I trust to give you good and patient counsel for investing in your retirement. The Biden administration has caused a financial crisis, and they have no clue how to fix it. Oil prices have skyrocketed, and when oil prices go up, not only do your expenses go up, but the cost of transportation and shipping spikes, leading the prices of goods to rise. And we are already seeing record inflation. That's the last thing that we need. Our economy is in trouble, and you need to take steps to protect yourself. If all your money is tied up in stocks, bonds, and traditional markets, you may be vulnerable. So gold is one of the very best ways to protect your retirement. No matter what happens, you own your own gold. It's real, it's physical, and it's always been valuable since the dawn of time. Call Legacy Precious Metals today at 866-528-1903 or visit them online at legacypminvestments.com. That's legacypminvestments.com, where you can download the free investor's guide. You can also go to my Facebook page, Jenna Ellis. I am a public figure on Facebook, and I just posted yesterday a really great interview with the president of Legacy Precious Metals, who is discussing why you need to start your retirement account even if you're in your 20s or 30s. There is always a great time to protect your retirement and invest, just like you want to protect your health over the long term. So go to Legacy Precious Metals at legacypminvestments.com or call 866-528-1903.
As a constitutional law attorney, former senior legal advisor, and personal counsel to President Donald J. Trump, Jenna Ellis believes in the rule of law and the importance of integrity in our elections. And she's ready to tackle the big cultural and legal issues facing America. This is the Jenna Ellis Show. Here is your host, Jenna Ellis.
Hello, friends, and welcome to another episode of the Jenna Ellis Show. I'm Jenna Ellis, and today we are going to celebrate Constitution Day, the 235th anniversary of the ratification of the U.S. Constitution in America's history in 1787. Of course, the actual Constitution Day is annually on September 17th, so today we're going to take a day out and celebrate the U.S. Constitution. And for those of you who are new to the show, welcome. Please subscribe wherever you stream, whether that is the audio channels on Rumble or on YouTube. And we will be bringing a lot of legal information, constitutional information, following the top stories in politics, culture, and of course, the Christian worldview. And so today, we definitely want to dive into the actual text of the U.S. Constitution, because a lot of you who listen to this program actually have asked me a lot of really good questions about the Constitution and about the amendments and, a whole host of other things. And so I wanted to just give a basic overview for people. And, while we say whether something is constitutional or not, and of course, there's always all these arguments on Twitter and social media and mainstream media about, what is constitutional versus unconstitutional. Of course, we have to describe what is the U.S. Constitution and how can we measure that? What do we compare that to? How do we analyze that? So, of course, annually on July 4th, we always celebrate Independence Day, which was the signing of the Declaration of Independence that was the first legal document in our nation's history. That, of course, was the inception of the United States of America, separate and distinct as a national sovereignty. That document provided the mandate for our system of government, which is ultimately reflected in the U.S. Constitution and all of the 27 amendments to the Constitution in our nation's history. But the Declaration is really important, and obviously the reason that we celebrate July 4th annually is because the Declaration recognized unanimously by our founders, by the then 13 colonies and the states of the United States of America, that we understand and we recognize as a nation that our rights come from God, our Creator, not our government. And so it's the sole purpose of government to preserve and protect are rights that come from God, our creator. So we can't even start having a conversation about what are our rights without recognizing God, our creator, because without him and without understanding that we are all human beings made in his image, then our rights are simply a matter of public debate. They're a matter of what the sovereign in our current country, the Congress, or the runaway tyrannical government of the Biden administration will tell you your rights are. So this is where we get to these current hot topic debates like whether or not abortion is a right. And obviously, when we look at that in the context of our current political climate, that debate is without grounding in most of the ways that even conservatives articulate it. We can talk about many reasons why we would argue and advocate that abortion isn't a right, and the extremist left and the pro-choice feminists and Planned Parenthood and everyone else can tell us and argue all the reasons that they think it should be a right. But that's all just debate. That's all just opinion. And we need to be certain that we have the only correct argument and the only correct observation, that it's not actually a right in the Constitution, because the Constitution doesn't give us our rights. God, our creator, does. And America is so unique in our system of government, and why we celebrate Constitution Day, why we celebrate the fact that we are the greatest nation that has ever existed on the face of the earth, is because of that simple, unalienable truth, which is that our rights are vested in us as human beings made in the image of God, because God endows them to us. Our government does not give them to us. Our Constitution, our supreme law of the land, doesn't give them to us. And so likewise, our government or our Constitution or amendments or legislation from Congress or opinions from the Supreme Court can never take those away or diminish those rights or infringe upon them, because they're part of our intrinsic humanity. And that's what the Declaration recognized. The founders didn't just collectively agree that that's how they wanted to proceed. It was a collective recognition of self-evident truth, just like we would observe the laws of, as they termed them, the laws of nature and of nature's God. We observe the laws of physics. We observe how the universe around us works, and we simply observe those laws. We label them, we figure out how they work, but we didn't get together as, a bunch of mathematicians and say, what we think would be really great is we're going to legislate the law of gravity, and we're going to decide that that's a good law of physics that we want to legislate. No, that law exists separate and apart from any human understanding of it or designation of it or observation even of it. The law of gravity existed and was in full force and effect before you or I ever realized or learned in school that it existed and how it works. And in the very same way, the laws of moral truth and the laws of God in every aspect, including the truth of morality and the truth of our rights and the truth of our identity as human beings made in his image, that isn't up for debate in any sort of construction sense. So when we talk about our rights, we are not constructing or agreeing or legislating anything. We are simply observing the truth of reality that God has presented us with and observing our natural world. Our world is not just this secular sort of amoral course of life, in the sense that laws and policy that govern civil society and humans are the only type of moral laws that we could construct. All law is inherently moral. And so when we look at the universe around us, when we look at the measurable difference between right and wrong, good and evil, our founders recognized for the first time in world history that rights aren't a matter of collective judgment and social construct. Law is a matter of truth. And so they wrote this beautiful declaration recognizing that intrinsic, unalienable fact, and then mandated that we as Americans would create a system of government that best protected and preserved that truth for all Americans. And our Constitution, of course, there are so many arguments from all of the different leftists, like the 1619 Project and others, that say, well, we were racist at our very inception, and we valued one set of humans over another's, and categorically. And the Three-Fifths Compromise, which of course was how to determine representation in Congress. And in our representatives per state. While we can argue that that was not, in fact, the best way for representation, it wasn't actually diminishing human beings in terms of their intrinsic value. It was for the purpose of representation. Now, at that time, women weren't represented. Women didn't vote at all. So it wasn't even three-fifths. Women were basically, not even categorized in terms of representation. We have corrected those flaws and adjusted and tweaked our system of government based on the ability that the founders gave us to create a more perfect union and have a better model and system of government based on that truth as we have continued along. And so whether or not you like certain aspects of the Constitution, and we can debate those separations of powers, those delegated authorities, and whether or not they best preserve and protect our rights. For purposes of this conversation today, the point is that the Constitution does not delineate, define, or give us our rights. Our rights are defined by God Himself and by the fact and the self-evident truth that human beings all have inherent dignity and worth and are made in His image. So when we talk about things, and it always, it's laughable to me actually that the left is so concerned about, this three-fifths compromise when they're the ones that are suggesting that not just for a matter of representation in Congress, which we could argue was foreclosing the rights of slaves at the time, and of course foreclosing rights of women at the time, but just foreclosing right of representation in government is a completely different moral question than saying your life is totally invaluable and you are able to be killed at whim if you aren't born yet. And so that category of persons and human beings that the left is saying are not valuable based on age, based on size, based on a totally arbitrary metric, that's just totally inconsistent logic. And so as we have continued to perfect our U.S. Constitution, and I think we've stumbled at various points along the way, like the 16th Amendment and 17th Amendment and so forth, we can go back and we can repeal certain things, we can modify and we can change. But what can't change is the recognition of self-evident truth. And so the Declaration gave us our mandate, and the way that our government is obligated and mandated to preserve and protect our rights doesn't change. And it can't change unless we cease being the United States of America under that declaration and under this supreme law of the land. And so what we have to recognize, in the ultimate point of this conversation, is that our Constitution does not give us our rights. Our Constitution simply provides limited power to the federal government and then reserves some power to the states and the state government to operate specifically to preserve and protect the rights that God Himself has given us. So how does the Constitution do that? And when we talk about what is unconstitutional versus what is constitutional, we have to compare and contrast that action with what power has been given by the Constitution to that particular government agent that wants to act. So, for example, let's just take this now same-sex marriage bill that is going through Congress. It, of course, came out that Congress is going to wait until after the midterms to take a vote on that. And when you look at the limited power that the U.S. Constitution provides to the Congress, issues and regulation of marriage and domestic relations as a whole is not given to the federal government. It's given to the states. And the states can decide how they want to regulate domestic relations issues. If they want to regulate, there's some great arguments that the government needs to get out of the marriage business as a whole. It obviously cannot infringe upon the free exercise of religion. It obviously cannot tell churches how or if they have to participate in or recognize certain types of marriages. And all of those are state level issues. And so for the purpose of the U.S. Constitution, the federal Constitution doesn't give Congress that subject matter to legislate on. And the reason for that is very simple, because our founders wanted in a federalist system where the federal government would have some power and then most powers, in fact, all powers not given to the federal government were reserved to the states or to the people. The limited powers that are given to the federal government are for the purpose of protecting the union as a whole. And so if you think about it, domestic relations issues has nothing to do with our federal government and what it's designed to do. And what Congress has, and on both sides, Democrats and Republicans, what they have forgotten over the last 60, 70, 80 years is that their role is not to make everything in every state exactly the same. Their role is to provide limited power, or to act on, rather, limited power that the Constitution has given the legislative branch to legislate according to what power and purpose the federal government is obligated to. So things like, for example, a uniform rule of immigration and naturalization, because anyone coming into any state in the country obviously affects the rest of the states. It's to make sure that there aren't tariff wars between the states, to have a single form only of coin. Only the U.S. government can coin money. So, I mean, imagine if there was a difference in monies from Colorado versus the state of Maine, and what's the exchange rate and how do we know that? I mean, the founders didn't want that. We are all part of the United States of America, so we have one common currency. Protecting the borders, declaration of war. I mean, imagine if the state of California could declare war and rope in everyone else. On the flip side, for the liberals listening, imagine if Florida could make a declaration of war and that would bind everyone else, right? So the states should not be able to speak on behalf of the whole and have that sort of federal power. But the federal power needs to be very, very, very limited. So if you actually look at the text of the Constitution and the 7 articles that are the original U.S. Constitution, and then, of course, we have the 27 amendments that are part of and have full force and effect like the rest of the Constitution, the first 7 articles simply designate what limited powers our founders in their wisdom said this is necessary, that the federal government can control these specific powers. So Article 1 is all legislative authority, all the power to make laws on the federal level. And Article 1 starts with Section 1, all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. So all legislative powers. So what does that mean? Well, that means that no other power granted to the federal government no other legislative power is given to any of the other branches. So the executive can't make law. The judiciary can't make law. That's really important. But if you go down to Section 8 of Article 1, and, obviously there's a lot more in Section 1 about the legislature and the bills and all of those things. So Section 8, though, actually describes in just a couple of subsections what specific legislative authority Congress actually has over certain subject matter. So, for example, Section 8.1 says Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay debts, and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. Do you see this common thread that the federal government and the point of the federal government and the limited power given to our national federal government is for the general welfare of the whole United States and for uniformity of those things that are necessary to keep the union together. But it's not to make sure that there is complete uniform rules and laws throughout and within every single state on everything. So 8.2, to borrow money on the credit of the United States. 8.3, to regulate commerce with foreign nations and among the several states. The Commerce Clause is a whole other podcast we'll have to do some other time, and how that has gotten wildly completely distorted and stretched to an absolute breaking point with the Supreme Court. To establish a uniform rule of naturalization and uniform laws on the subject of bankruptcies throughout the United States. 8.5, to coin money, to regulate the value thereof, and a foreign coin, and fix the standard of weights and measures. So all of these things going all the way down through Section 8.18, which then is the other kind of general welfare clause that says to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. So the necessary and proper clause in this context, in Article 1, Section 8, is not just whatever Congress thinks is necessary and proper, like, oh, we want to run out and make sure that we codify the right to gay marriage or the right to abortion or, the right to anything else that Congress happens to think is a good political policy heading into the midterms or 2024 election. It's to make all laws which are necessary and proper for carrying into execution what? The foregoing powers. So only those things that were actually designated and limited powers that were given to the legislative branch only to legislate on a very, very small set of subject matters. That's it. And imagine the difference in the United States if Congress were actually limited to just those things that the Constitution actually provides power on. We would have an actual federalist system. We would have a system of federalism in the United States, and governors of states and state legislatures rightly would become vastly more important, and people would have to start considering even more than they already are whether they want to live in California or Florida or Texas or Pennsylvania or wherever the laws of that state provide the most protection for their God-given rights on a state level. And so much of our civil society and the challenges and the policy debates and issues that we face should properly be on a state level. This is why the Dobbs opinion, regardless of what you may think about abortion, is not a federal issue. It is a state issue. And the reason for that is because the powers given to the legislative branch do not in any way concern the regulation of abortion. That is a state level, just in the same way that the federal government is not given authority. Congress is not given the power to regulate a uniform rule on capital punishment. That concerns issues of life. It concerns issues of due process, even, some of which are given to the federal government to protect, and in our Bill of Rights, which we'll talk about in a few minutes. But all of those things, those can be different in the states. And even though some of my colleagues, and I think there is a good argument that while Congress cannot regulate abortion and tell the states that they cannot ban abortion, that Congress could ban abortion completely, I don't see that in the text of the Constitution. And obviously, there are some that would say, well, other amendments can, in the sense and the language and all of that, we can make an argument. Well, a textualist and an originalist view of the Constitution would say we need to confine federal government to the limited powers that it was actually granted, and for the purpose of preserving and protecting the rights that God has given us. In that limited power sense only. Now, would it be great if Congress made a lot of laws that I happen to like? Sure, I might like that from a policy perspective. But from a constitutionalist, conservative, originalist position, I can't advocate for even the laws in Congress that I might think are great when there is no power that's actually given to the federal government and given to the Congress to legislate on. So, for example, this might be something like election laws. That is not a power to determine how the method in which electors to select our president of the United States, that is specifically given to the state legislatures. The only thing that Congress has power to do is set the time, place, and manner that is uniform throughout the United States, which makes sense so that one state doesn't say, well, you know what, we're going to have our electors in January and someone else in December, and then it's this totally distorted election for a national office. That makes sense that for federal elections, Congress can set the time, place, and manner. But then within the state system, it's different. So the states and the state legislature have the authority of determining their electors. Why? Because that's representation of the people in their state. Congress has no power. Congress actually needs to be and should be representatives of the state. We've also lost that concept in our constitutional structure, that Congress, and particularly the Senate, is supposed to be a representative not just of the people of the state itself, but also of the state legislature. This is why I think the 17th Amendment to the Constitution was ill-conceived, because now senators are popularly elected. Well, senators, U.S. senators, were never meant to represent the people and the constituents. What they were meant to do was to go to Washington and represent the state legislatures, because the state legislatures were supposed to have so much more importance in terms of governance, to be closer to the people. And the best way to keep the power in Washington in check is for the state legislatures to be able to seat their senators and to recall their senators at will. That's what we had in the original design. And the original design made sense until people, a lot further down the road forgot, didn't understand, or intentionally wanted to distort this and have a popularly elected Senate. And now you have senators who can just, go on TV and can make a great case and can manipulate the constituency and the vote in their particular district without, and by manipulating the vote, meaning, having people vote for someone or they're a policy position that they don't even really know what they're voting for. And they can do that instead of being accountable to the state legislatures. The state legislatures now have absolutely no say what goes on in the United States Congress. That's not how it was designed to be. We have limited powers to our federal government in a federalist system. And the state legislatures were supposed to be vastly, vastly more important, because those are the people who are closest to you and I, the citizens of the states. So if you look at the design and the parameters and the limited powers in the Constitution, it's actually brilliant in its design. And the founders understood, coming from this really amazing world history and heritage and understanding of the types of governments that had come before, that the lawmaking, the execution of the law, and the decision-making of the judiciary, the arbitration of disputes, and also church power cannot be vested in one single person. That's the way that it is, and it was throughout world history in Great Britain. You had the king, who was essentially the head. I mean, and now they have the parliamentary system and all of that, but there's a lot still that's governed by the monarchy. And of course, in Old England, when the king would just make these mandates and decrees and do whatever he wanted, and then execute the laws, and then also was the arbiter of disputes. It was one person, or even one body, if he went to his privy council, that decided everything. Our founders decided to separate those powers into all legislative authority. And then Article 2 is all about the executive. And the executive in Article 2 is about the presidency, Section 1, the same thing as Article 1, except for the executive. The executive power shall be vested in a president of the United States of America. So all executive authority is on the federal level is in our president. And then Article 3 is the judiciary. And Section 1, same thing. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. So Congress can create the circuits, the federal seats, the federal system of the judiciary, and also this is where we get into the policy debate of expanding the seats on the Supreme Court. That's given to Congress. And whether or not that's a good idea is debatable, but Congress does have that authority. But the judicial power itself, the power to arbitrate disputes on the federal level, is given to one Supreme Court and other inferior federal courts. So we separate powers. And then importantly, Article 4 is all about the states. So it talks about how states can join the Union. Importantly, the Constitution is silent on state secession. That is a very contentious issue, and one that I would argue state secession, because there is no mechanism within Article 4 of how a state, once it becomes part of the Union, can secede. That secession is by definition unconstitutional because there is no process or procedure. Now, if we wanted to add that into Article 4 or into an amendment that would thereby amend Article 4, we could do that, but it's currently silent on the subject. So we have Article 4 that talks about full faith and credit will be given to each state to public acts, records, and judicial proceedings of every other state. And so the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. But importantly, they don't legislate on a state level. So Article 4 is all about the states. Then Article 5 is this wonderful idea of how we can amend our Constitution. So our founders knew, they weren't going to get it right the first try. They got a lot of things right. But they gave us the ability, rather than having to overthrow our government or create a brand new constitution every time we wanted to change something that wasn't precisely the best way of fulfilling the Declaration's mandate, then we have this way that we can amend our supreme law of the land. We can say, we don't like that we gave the limited power to Congress, for example, let's say for the popular election of senators. We amended the Constitution to change the method by which we appoint U.S. senators. And so we could change that again. And we've changed that to allow properly women to vote, to have the Reconstruction amendments in the aftermath of the Civil War. All of these things to create a more perfect union, to make sure that we are best preserving and protecting the inalienable God-given rights of every human being in the United States of America who are citizens and who've gone through the uniform rule of immigration and naturalization. right? So we have the amendment process. And quickly, there are two ways to amend the U.S. Constitution. One is that Congress can originate an amendment. That's the way that we've actually amended the U.S. Constitution every time, is through this way, which is that Congress can create an amendment, has to pass by a 2/3 majority of both houses, then has to be ratified by 3/4 of the states. So there are a lot of amendments that have failed in this way because either it didn't pass through Congress or it passed through Congress but wasn't ratified by 3/4 of the states. That would include things like the Equal Protection Amendment. That ultimately was not ratified by a sufficient number of states, so it failed. But we can do that, and it is a very difficult process to amend the Constitution, and that's by design. That's a good thing. We don't want to have an arbitrary system of government that can just be amended almost at whim. That's why the Democrats and a lot of these other activists have tried to, in effect, amend the Constitution through executive order, executive powers, through now Emergency Powers Acts, and also historically through the judiciary. So they try to amend the Constitution and the practical effect through the judicial branch. That's not what the Constitution was designed for. So the other way of amending the U.S. Constitution is through what is called a convention of the states. It is not a constitutional convention. That is a misnomer, but a convening of delegates that are sent by the states to be representatives to come together to debate specific amendments and specific subject matters. So importantly, if 2/3 of the states were to pass the same resolution, the same subject matter, saying, for example, we want to have judicial reform, or we want to have, balancing the budget, or whatever the subject matter was. If 2/3 of the states in both houses in the state legislature were to pass the same resolution, then the convening of all 50 states would come together in a convention. They would debate the text of the amendments. They would have to then pass out of that convention the text of one or more amendments, which would then have to follow the same process, and each amendment passing through that convention would have to be ratified by 3/4 of the states. That has never been done in America's history. We're very close. Our friends at the Convention of States Project is the closest that we've come to having a convention of the states. And their Convention of States resolution is uniform so that it will pass out of each of the states that wants to pass it out of, and then a convention of states would be called. There are a lot of different ideas about a convention of the states, whether it could be a runaway convention, and we would overhaul a lot of other things that aren't even up for debate. But the text of Article 5 itself limits the subject matter to what is in the text of the resolutions that would pass in each state legislature, just like in our 27 times of amending the Constitution in American history. We have never had this idea that, if we pass Amendment 27 or Amendment 28, then somehow everything else in the Constitution is up for debate. Well, no, because the only thing up for debate and up for ratification would be the text of that particular amendment. So it's not actually as complicated as some people would make it seem. So that's Article 5 in the amendment process, so that we can have a system that we can pivot, we can make sure that it stays on course toward the objective of preserving and protecting our rights. Then we have Article 6, which is simply the legal status of the Constitution, saying, for example, in Section 1, all debts, contracted, and engagements entered into before the adoption of this Constitution shall be valid against the United States under this Constitution as under the Articles of Confederation. Section 2, this Constitution and the laws of the United States, which shall be made in pursuance thereof, limited powers. All treaties made or which shall be made under the authority of the United States shall be supreme law of the land, and judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. So This is another aspect of the supremacy nature of our supreme law of the land. States are still under a federalist system, and so states cannot go against the United States Constitution and say, well, you know what, we don't like the fact that we can't coin money, or that we can't impose tariffs on our neighboring state, or we can't declare war, or whatever. So we're going to go ahead and pass a law that is against the Constitution and try to encroach upon the power of the Congress. Well, no, they can't do that. And that's for a reason, right? Because we separate powers in the United States, and we have the separation on the federal level of the legislative, the executive, and the judicial. And then we also have it vertically in our federalist system between the federal, the states, and then also all the powers not given expressly to those two levels are reserved to we the people to determine for ourselves how to self-govern. So it's a beautiful system. And then finally, the ratification of the Constitution, Article 7, is the ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states, so ratifying the same. And that's just kind of the legalese. And then, of course, we have our Bill of Rights, which comprise Amendments 1 through 10. Those were ratified at later times, very shortly after the ratification of the U.S. Constitution. And our Bill of Rights is what I like to call a redundancy clause, or a redundancy protection. Because remember, when we talked about Article 1, Section 8, and these are the very specific things that Congress has the limited power to legislate in pursuance thereof. Amendments 1 through 10 remind Congress, you can't. These are the things that you can't. So Amendment 1 starts out saying, Congress shall make no law. Congress, we are reminding you, just in case you weren't clear, that Article 1, Section 8 does not give you power over these specific things. Now, it's not all-encompassing. Obviously, you can't have a whole laundry list of all of the negative space of the things that are not listed in Article 1, Section 8. The founders, in their wisdom, determined to expressly tell Congress, these are certain rights that the people already have, that you cannot abridge, infringe upon, or make any law regulating these things. Now, this has been vastly warped out of proportion to say that, for example, in our Second Amendment, that because the text of the Second Amendment says the right of the people to keep and bear arms shall not be infringed, that if we were to repeal the Second Amendment tomorrow by an Article 5 process, that suddenly we the people would not have any entitlement or right to keep and bear arms. Well, that's simply false. All that the Second Amendment is saying, it doesn't grant our rights to keep and bear arms. It's simply recognizing that we have a right to keep and bear arms that is God-given, not government-given, and Congress cannot legislate to infringe upon that right. So any of these gun control measures, when we talk about constitutional versus unconstitutional, it is unconstitutional. First, because Congress, in Article 1, Section 8, is not given legislative authority for it. If it's the president who's trying to enact an executive order, well, you're not legislative. You can't legislate anything. Sorry. Unconstitutional. No power is given to the executive. In the Congress, no power is given to regulate the right of the people to keep and bear arms. Now, if we're talking about commerce and interstate selling or manufacturing of arms, Congress does have some authority to regulate certain aspects, but definitely not the individual person from keeping and bearing arms, right? And the Commerce Clause is just about packing and shipping. That's literally it. It's just about to make sure that there aren't these tariff wars between the states. So even in terms of if it was over-regulating, like what the executive orders through the OSHA mandates in COVID were trying to do, and tell businesses in every single state how they had to enforce a vaccine mandate. That is so overbroad. It's so ridiculous because there's no power that's given to the federal government in any branch to regulate those things. There are and most executive agencies are unconstitutional because there is no power given to Congress to legislate on that subject matter, and so for the executive to enforce. So a lot of these agencies, Department of Education, Department of Health, all of these things, unconstitutional. They have no power in the Constitution. And so the Bill of Rights does not give us or grant us any rights. It is simply saying, Congress, in case you weren't clear, and believe me, they are very not clear in 2020, in case you weren't clear, these are rights that are so sacrosanct, so intrinsically embedded in who we are as human beings, made in the image of God, and our right to live our lives freely, to freely speak, pursue happiness, right? Life, liberty, the pursuit of happiness, all of these things that we want to make sure that Congress knows you can't legislate on these things. So Amendment 1, our very first amendment, starts out by saying, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people to peaceably assemble and to petition the government for a redress of grievances. Congress can't say, sorry, you can't. The Constitution is saying, Congress, you have no power. So it goes down and protects, of course, our right to keep and bear arms, and the 4th, 5th, 6th, 7th, 8th Amendment. There's actually more in the Bill of Rights about fundamental due process in a criminal justice context. Why? Because the founders were concerned that an overreaching, overbearing federal government would have malicious and political prosecutions. So they established and said, these are certain due process rights to make sure that life, liberty, and the pursuit of happiness, these God-given rights, are protected procedurally in a criminal context. And then, of course, the 9th and 10th Amendments. The 10th Amendment is very clear that, quote, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. And that's as simple as it is. So we have our Bill of Rights, and then, of course, we have the rest of the 17 amendments in the course of our nation's history that have amended the Constitution to give more power to the federal government, for example, through laying and collecting income tax through the 16th Amendment, which I think was a bad power to give to our Congress and our federal government. We could certainly take that away by repealing the 16th Amendment. And then, of course, the 17th Amendment, like we've talked about, which changed the nature and the way that we appoint and now elect U.S. senators. So if we go all the way through, then these amendments, all it does is change and modify slightly in the context of the amendment what powers are given to which branch of the federal government. But we celebrate Constitution Day, and I actually think it's the second most important national holiday, apart from, of course, July 4th and the wonderful unanimous Declaration of Independence that recognized fundamental truth of our rights given by God, not our government. Our Constitution preserves and protects that through limiting powers and separating those powers among the federal government and federalism, which provides for a very limited federal government into the states. So if you want to know how to restore freedom in this country and to cure the corrupt, disgusting underbelly of the swamp in Washington, it is through restoring states' rights and limiting Congress and the executive into the parameters and the limited powers that our Constitution actually provides. So this has just been an overview of the 7 articles of our U.S. Constitution, our 27 amendments, but that's all that it says. And I would encourage you to go and actually read it. Of course, it's just the nuts and bolts. It's the legalese of what powers are given to which branch, but it's very clear. And it expressly designates these powers. And so when we answer the questions of what is constitutional versus unconstitutional, that's all it is. Is the power that Congress wants to exercise given to it by the Constitution? Is it in Article 1, Section 8 or anywhere else in the Constitution? If it's not, then sorry, it's unconstitutional. And it doesn't matter if I like it or I hate it, or you like it or you hate it, or if we think it's a good policy or we don't, or, our favorite representative or legislator on television thinks it's a good idea. If the Constitution does not give Congress that power or give any president a certain power, then they can't. Sorry. End of discussion. But within the context of what powers they do have, if it is constitutional, meaning if it is within the limited designated authority and power given to that particular branch. Because remember, the executive can't legislate, the legislative can't step into the executive. You cannot have that encroachment and violation of the separation of powers. So that would be unconstitutional as well. So if the particular government actor is wanting to exercise a power that is given to it, and it is then by definition constitutional, then we have the policy question. Is it a good idea? That's what's debatable. What is not debatable is whether something is or is not constitutional in a textual, originalist, conservative sense. It's very clear. We have to get back to the original text and design of the Constitution. We have to hold Washington accountable to their limited, separated powers, and we have to start electing people on the state and local level who will hold Washington in check and say, sorry, that is an abridgment of your power. You can't do that. That is reserved to the states and to the citizens of my state. And so we're going to legislate on this. We are going to decide for ourselves. So as you are debating these things, read the text of the Constitution, very simple. Look at these debates through the lens of, first, can the government? That's the constitutional question. Then should the government? And that's the policy question. And I hope that you will celebrate Constitution Day on September 17th this year and every year. And I hope that we have many, many more years to come celebrating the wonderful gift that is our U.S. Constitution and given by our founders in America. I'm so proud to be an American. I know President Trump is so proud to be an American, and this is why. So happy Constitution Day. Legacy Precious Metals is the company that I trust to give you good and patient counsel for investing in your retirement. The Biden administration has caused a financial crisis, and they have no clue how to fix it. Oil prices have skyrocketed, and when oil prices go up, not only do your expenses go up, but the cost of transportation and shipping spikes, leading the prices of goods to rise. And we are already seeing record inflation. That's the last thing that we need. Our economy is in trouble, and you need to take steps to protect yourself. If all your money is tied up in stocks, bonds, and traditional markets, you may be vulnerable. So gold is one of the very best ways to protect your retirement. No matter what happens, you own your own gold. It's real, it's physical, and it's always been valuable since the dawn of time. Call Legacy Precious Metals today at 866-528-1903 or visit them online at legacypminvestments.com. That's legacypminvestments.com, where you can download the free investor's guide. You can also go to my Facebook page, Jenna Ellis. I am a public figure on Facebook, and I just posted yesterday a really great interview with the president of Legacy Precious Metals, who is discussing why you need to start your retirement account even if you're in your 20s or 30s. There is always a great time to protect your retirement and invest, just like you want to protect your health over the long term. So go to Legacy Precious Metals at legacypminvestments.com or call 866-528-1903. MyPillow is having their biggest sheet sale of the year. You all have helped build MyPillow into the amazing company that it is today. Now, Mike Lindell, the inventor and CEO, wants to give back exclusively to you, his listeners. The Percale bedsheet set is available in a variety of colors and sizes, and they are all on sale. So, for example, the queen size is regularly priced at $89.98, but is now only $39.98 with our listener promo code Jenna, Jenna. So order now because when they're gone, they're gone. The Percale bed sheets are breathable and have a cool and crisp feel. These come with a 10-year warranty and a 60-day money-back guarantee, so don't miss out on this incredible offer. There's a limited supply, so be sure to order now. You can call 1-800-564-8475 and use the promo code Jenna, or go to mypillow.com/Jenna. You can click on the radio listeners square and use the promo code Jenna. That's Jenna. Thank you so much to all of Mike Lindell's listeners and listeners of this podcast for making sure to support My Pillow and using our exclusive listener promo code Jenna. That's Jenna.